Okay, thank you for joining us today for our 650 webinar 2021 year-end update on COVID-19 laws. My name is Ryan Parker. I'm the Chief Legal Product Officer here at 650, and we have a great webinar planned for you today. I'll introduce our three panelists, and then we'll talk about the agenda. Before I begin, let me just go over some housekeeping items. We welcome your questions, and I'm sure you'll have questions that may come up during the presentation. We'd ask you to put them into the Q&A function, which is at the bottom of your screen. That'll allow us to answer those questions. We'll answer some of them by typing in responses, and others we'll answer live on the webinar. In addition, I know that COVID-19 issues have been somewhat politicized in the media and other places. We're going to try to just give you the facts on COVID regulations and stay away from political issues, and we'd ask you to do the same in the chat and in the Q&A. We have three great panelists today, and I'll introduce them now. First, we have Adrienne Jack. Adrienne is a Vice President of Legal Product at 650. She attended one of the top law schools in the country before working at a well-known Washington, D.C. law firm. After that, she joined us at 650. Adrienne became a hero at 650 when she announced recently that she was naming her newborn child, who was born on May 4th, Star Wars Day, after a beloved Star Wars character. So Adrienne's a lot of fun and knows a lot about return to worksite and especially Cal OSHA, and we're grateful to have her on the program. Next, we have Marie Colbeth. Marie also attended a top law school before clerking on the Circuit Court of Appeals, just below the Supreme Court. She then worked at BYU Law School before joining us at 650 as our general counsel and as a vice president of legal product. And Marie has some amazing experience, not only helping us to build our products, but implementing our COVID-19 program at 650. When Marie's not doing amazing legal work, she can often be found helping students do Model UN on the weekend. So she's got a lot of interesting interests, and we're lucky to have her with us. Finally, we have Adam Wright. Adam went to what I would say is the best law school in the country, the University of Michigan, go Blue. Before clerking for two federal judges, he then worked at a couple of different law firms before joining us as a vice president of legal product here at 650. I like to ski, but Adam recently put me to shame when he explained that instead of taking the lift up, he likes to put skins on his skis, cross-country ski up the hill, and then telemark down. So he doesn't do lazy man skiing. He's actually a hardcore true skier, and in addition to being an excellent lawyer. So we're grateful to have all three of these presenters today. We'll now turn to the agenda. And let me say this before we go. One of the ways that we have learned about COVID is by building COVID-related tools, including our return to worksite tool set, our Cal OSHA tool set, and our New York HERO Act generation engine. And Marie, Adrienne, and Adam have been involved in those processes. If you're interested in learning more about those tools, feel free to visit us at www.650.com/return, where there's more information about all of our products. So today we've broken our webinar into three parts. We'll start with a look back at 2021's COVID-19 legal developments. There's been a lot of movement there at the state level, at the federal level, and with regard to legal challenges. And that should be an interesting section. We'll then turn and take a look ahead at 2022, COVID-19 laws and regulations, and we'll focus there on what's happening in California and New York, with some mentioning of some other jurisdictions. And then finally, we'll turn to COVID-19 best practice policies and practices for businesses in 2022, things that you can think about putting in place to be prepared for all the twists and turns that are likely waiting for us in 2022. And with that, I will turn the time over to Adam Wright, who will start with our look back at 2021 COVID-19 legal developments.
Thanks a lot, Ryan. So let's go to the next slide there. So before we jump into the current state of COVID laws and regulations, we thought we'd take a quick look back at COVID-related developments over the past year. So 2021 was obviously a big year in COVID-related news. The biggest development probably came in early 2021 when we welcomed the arrival of the COVID-19 vaccines. As you can see in this chart, as of this month, more than 200 million Americans have been fully vaccinated against the virus. The vaccines have proved highly effective in preventing serious COVID illness and death, including against new variants like Delta, and as the latest science seems to be indicating, also against the Omicron variant. But despite COVID now being a largely preventable disease, the US has just recently hit a really sobering number of 800,000 COVID deaths. And so in light of these circumstances, state and federal governments have been updating their COVID-19 laws and regulations. And as we head into 2022, there are a lot of questions about what businesses are legally required to do, both under state and federal law, around things like social distancing, masking, testing, and vaccination. And even if those measures aren't legally required, many businesses are thinking about what are the best practices to make sure that we have a safe workplace. And so these are the topics that we're going to explore today. But first, let's talk about some of the COVID-related legal developments over the last year, both at the state and the federal level. So at the state level, California, you will probably not be surprised to hear, was the state that implemented probably the strictest regulations on businesses to prevent the spread of COVID. Cal OSHA, which is the state's Division of Occupational Safety and Health, first issued emergency temporary standards, or ETS, in November of 2020, governing businesses' response to COVID in the workplace. In June of this year, Cal OSHA revised the ETS based on updated CDC guidance, and the revised ETS required a lot of things from businesses. So these are just a few examples. So required businesses to create a written COVID-19 prevention plan with several required policies in that plan. It set face covering requirements based on vaccination status, required employers to provide face coverings at no cost to employees, required employers to make testing available at no cost to certain employees exposed to COVID-19 at work. It set parameters for excluding employees from the workplace after a positive test or close contact. And in contrast to some of the most recent requirements we've seen, it did not include a vaccine mandate. We also saw movement in several other states that you see listed here that implemented laws and regulations aimed at curbing the spread of COVID. So things like vaccine or testing requirements for certain state workers, nursing home staff, and or workers in healthcare facilities. Let's go to the next slide. So in 2021, we also saw a group of states that took a very different approach than the states we just talked about. So this group of states sought to curtail workplace vaccine mandates. And many of these actions were in direct response to President Biden's executive order mandating vaccine and testing requirements in the private sector, which we will talk about in just a minute. But in Texas, we saw the governor there, Governor Abbott, issue an executive order saying that no entity in Texas can require any individual, which would include an employee or a consumer, to get a COVID-19 vaccination who objects based on personal conscience or religious or medical grounds. That executive order, interestingly, said that it would expire if the Texas legislature passed the law consistent with that order during a special session, but that legislation failed to pass after business groups were really vocal in opposition to it. In Utah, the legislator there passed a law that didn't outright ban vaccine mandates, but it did require employees with vaccine mandates to include exemptions for health reasons, sincerely held religious beliefs, and also sincerely held personal beliefs. Now, that last category was somewhat surprising because it's a new term that was left undefined by the law. It's an exception or exemption that we haven't seen in the law before. And so, we are left with the question of what is a sincerely held personal belief, and how are businesses supposed to determine whether an employee's personal belief is sincerely held? Are there any personal beliefs that aren't sincerely held? So unfortunately, businesses operating in Utah are now left sort of wondering how that exemption will be interpreted, and that remains to be seen. Like Texas, Tennessee, and Montana have sought to ban employer vaccine mandates entirely. In Montana, vaccination status is now a protected category under the state civil rights law. There are more states that have followed this path. These are just a few examples, but it gives you a good example of what we're seeing at the state level. It's important to note that if the federal vaccine and testing mandate survives legal challenges, which we'll talk about here in a minute, these state laws will likely be preempted by the federal laws to the extent they conflict. So again, a lot depends on the ultimate resolution of the legality of the federal vaccine and testing mandate, which remains to be seen. All right, so let's transition now to take a look at what we saw on COVID-related regulations in 2021 at the federal level. So let's start with the CDC. The CDC guidelines changed often in response to rapidly evolving science around COVID-19, and this left a lot of businesses really struggling to stay up to date with the latest guidance. The CDC guidelines are not binding on businesses, but they did set out best practices for businesses, and they also informed actions states were taking to stop the spread of the virus. So in March 21, the CDC recommended that fully vaccinated people can gather indoors without masks. The next month, they recommended that fully vaccinated people can travel safely domestically without a COVID test. In July, they sort of went back a bit and recommended that fully vaccinated people should resume wearing masks in public indoor settings in areas of high transmission rates. And then obviously throughout the year, there were various recommendations on vaccines, but the most recent of which was last month when the CDC recommended boosters for everyone 18 and above. All right, so let's move to the next slide and talk about what we saw in terms of executive orders from President Biden. So in March of 2021, President Biden directed all states to make all adults eligible for vaccines by May 1st. And then probably the biggest headline was in September 2021, when President Biden announced his COVID-19 action plan called Path Out of the Pandemic, which required vaccines for federal contractors, executive branch federal employees, and workers in healthcare settings receiving Medicare or Medicaid reimbursement. And then probably most controversially, the executive order ordered OSHA, the Occupational Health and Safety Administration, to develop and issue an emergency temporary standard requiring private sector employers with 100+ employees to mandate vaccination or testing for employees. So importantly, the ETS does require employers that do implement vaccine mandates to provide exemptions for medical reasons or for employees that are entitled to reasonable accommodations under federal civil rights law for disability or sincerely held religious beliefs. But let's move to talk a little bit just briefly about what the ETS includes. So in line with President Biden's executive order, OSHA issued the federal ETS on November 5th, 2021. It required a lot of things. And if you're interested, we gave a webinar on this recently, which you can find online, that goes into much more detail about what the ETS require. But among other things, it requires employers with at least 100 employees to adopt a vaccination policy that requires employers to either be fully vaccinated, or if they're not fully vaccinated, to submit to routine testing. It requires covered employers to have a written COVID policy, and it requires certain paid time off for vaccination and recovery from side effects. And then it requires the exemptions that I just talked about as well. So what's the current status of all these state and federal laws and regulations, and where does that leave businesses? Let's move to the next slide here. And we're going to talk about legal challenges to the federal laws and regulations. So unfortunately, we don't really have a clear answer on where things stand yet, because many of these laws are in the middle of litigation right now. But so far, and again, this is very broadly speaking, state level laws and regulations aimed at curbing the spread of COVID have found more success so far in the courts than the federal laws and regulations. Although it's important to keep in mind that no ultimate decision has been reached yet on the legality of these measures because they're still being litigated. But as you might be aware, the federal ETS have been paused since the Fifth Circuit Court of Appeals enjoined implementation of the ETS in November. Lawsuits were filed all across the country in all the different circuits challenging the ETS. Unlike most lawsuits, the OSHA Act allows for lawsuits to be filed directly in the Federal Court of Appeals instead of the district court, which is where most federal lawsuits start. And so because they were filed across the country, they have recently been consolidated into one court, and it's consolidated in the Sixth Circuit Court of Appeals now. And so the case is now pending in the Sixth Circuit Court of Appeals. It is current in active litigation there. So most recently, OSHA filed a motion asking the Sixth Circuit to lift the stay and allow the ETS to go into effect while the lawsuit continues. Briefing on that motion was just completed a few days ago, and many observers expect the Sixth Circuit to hold oral arguments very soon and issue a decision potentially by the end of this month. But no matter what the Sixth Circuit decides, it is widely expected that the issue will end up before the Supreme Court. So there's likely some more waiting to be had there. The Biden administration's other vaccine mandates have also been challenged and are in similar legal positions. So the federal contractor mandate, as well as the healthcare worker vaccine mandate, have been enjoined by federal courts while the lawsuit proceeds. But in contrast, the federal employee vaccine mandate, although it has been challenged in several federal courts, so far that law has not been or that requirement has not been enjoined. And so the federal employee vaccine mandate is currently in effect, although it's being litigated. Also, in contrast to the vaccine mandates, the federal mask mandates for travel have so far fared better in the Supreme Court. So let's move on to the next slide and talk about legal challenges to state action. So as I mentioned, vaccine mandates at the state level so far have found more success in the courts. In the second half of 2021, the Supreme Court issued orders on several emergency appeals challenging state vaccine mandates. Emergency appeals are different than normal cases in front of the Supreme Court because they're decided by just one justice unless that justice refers the emergency appeal to the full court. So in August of 2021, Justice Barrett denied an emergency appeal from students at Indiana University to block the school's vaccine mandate. The next month, the full US Supreme Court declined an emergency request to block Maine's requirement that healthcare workers be fully vaccinated, even though that requirement did not contain an exception for sincerely held religious beliefs. That same month, Justice Sotomayor denied a group of New York City public school teachers' request to block the vaccine mandate for public school employees. In November, Justice Breyer denied a request from Massachusetts hospital workers asking the court to block the hospital's vaccine mandate. And then just very recently, the full Supreme Court denied a request to block New York State's vaccine mandate for healthcare workers, despite the fact that that had no religious exemption. So where does all this leave employers going into 2022? Unfortunately, there's a lot of uncertainty. So as we can see from the Supreme Court's action so far, justices across the political spectrum are allowing state vaccine mandates to stay in place, but it's hard to know exactly what that says about what they will do when the federal ETS challenge reaches the court, which it is expected to do, because the federal mandate presents a lot of different legal issues than the state mandates. And so legal scholars are really on the fence about whether the Supreme Court will ultimately uphold the ETS. So in a moment, Marie is going to talk more about best practices for businesses while we're in this legal limbo. But we are recommending that companies familiarize themselves with the ETS and have a plan for implementing its requirements if it is ultimately upheld. And so with that, I'm going to turn the time over to Adrienne, who's now going to talk about some of the latest updates to state-specific COVID regulations.
Thank you, Adam. As we look towards 2022, there has been a lot in the news recently about new legislation that either goes into effect right now, goes into effect the end of the year, or goes into effect in January. So California and New York have been all over the news for their new COVID legislation. So those are kind of the two states to watch when it comes to new legislation for COVID in 2022. So the first piece of legislation out of California was issued on Tuesday, and California issued a statewide mask mandate requiring masks in all public indoor settings. And this mask mandate is in effect until at least January 15th of next year, at which point it will be revisited and they will look at the state COVID statistics to determine whether that needs to be continued or it will be lifted. We already know that several California counties have mask mandates that were implemented this summer and that are still in effect. So like Los Angeles, Ventura, and Sacramento counties, as well as a lot of the San Francisco Bay Area already have mask mandates, but now that mask mandate will be in effect nationwide. California is also tightening restrictions on unvaccinated people attending large public events. And California defines large public events as an event with more than 1,000 people. So in order to attend those events, individuals must show proof of vaccination or have a negative COVID-19 antigen test taken within 24 hours prior to the event, or a negative PCR COVID-19 test taken within 48 hours prior to the event. Another big piece of legislation out of California that is actually being decided on today, let's move forward to the next slide. So Adam indicated that Cal-OSHA implemented their own ETS emergency temporary standards last November, and California was kind of the leader when it came to COVID emergency temporary standards. And it kind of signaled what might be in the federal ETS based on what we saw in California. So California's ETS was updated this past June to account for the wide availability of vaccines. So it loosened up some of the requirements for fully vaccinated individuals. And those ETS are set to expire on January 14th. So on October 20th, and then again on December 3rd, Cal-OSHA issued proposed revisions and readoption of their ETS. And those will be up for vote today by California's Safety and Health Standards Board. And if they're approved, they will go into effect on January 14th and stay into effect at least through April of next year. One interesting note about these California's new ETS is that even though they were revised after the federal ETS was issued, they still differ from the federal ETS in several ways. So let's move forward to the next slide. This is just one page of a multi-page document indicating some differences between the federal ETS and Cal-OSHA's ETS. And as you might know, if the federal ETS is implemented, if the state is lifted, then states with their own OSHA programs, such as California, will be required to adopt standards that are at least as protective as the federal ETS. So right now, there are some key differences between the Cal-OSHA ETS and the currently on hold federal ETS. So if those are implemented, California will need to revise their ETS yet again to make sure that they have all of the standards in the federal ETS. So one noticeable difference, for example, is that in California, the current ETS doesn't require vaccination or testing. That is left up to the employer to implement their own policy. But as we know, the federal ETS has a requirement that employees must either be fully vaccinated or submit to routine testing. So that's one big area that Cal-OSHA would have to revise in their ETS if the federal ETS is implemented. And it's also worth noting that Cal-OSHA's ETS applies to companies if they have at least one employee who is in contact with other persons in the workplace, which is more protective than the federal ETS that only applies to companies that have 100 or more employees. So there are a lot of differences, which leaves companies in tricky positions if they're in California as well as in other states where the federal ETS might apply, because the standards are different in some significant ways. Let's move to the next slide. I want to highlight just some differences between what we're seeing in Cal-OSHA's revised ETS and what's currently in the ETS. So right now, companies in California are required to have a written COVID-19 prevention plan. And under the revised ETS, companies no longer need that separate plan, but they can include their COVID-19 prevention information in their injury and illness prevention plan, which companies are required to maintain under Cal-OSHA. Also, we're seeing some buttoning up of the requirements for vaccinated employees. They were loosened this past summer in June by Cal-OSHA's ETS, but those are tightening back up again in this new proposed readoption of the ETS. So employees who were exposed to COVID-19 were able to return to the workplace sooner if they were fully vaccinated, but now the standard is the same for vaccinated or unvaccinated employees, that they can return to the workplace after 14 days of contact or 10 days after contact, but they also have to wear a face covering and socially distance for 14 days or 7 days after contact if they receive a negative COVID-19 test, wear a face covering and socially distance. So we're just seeing some heightened requirements due to the new COVID-19 variants that we've seen. Let's move forward a slide. Also, the testing requirements are now going to be applied to vaccinated employees. Previously, companies only needed to provide testing for unvaccinated employees exposed to COVID-19 in the workplace, but under the proposed ETS, companies would need to provide testing for all employees in the workplace, regardless of their vaccination status. Also, based probably on the federal ETS, the list of acceptable COVID-19 tests in the proposed ETS is going to be expanded. Right now, the ETS only acknowledges viral tests, but this could be expanded to include at-home tests, over-the-counter tests, and point-of-care tests. And just like we've seen in the federal ETS, those COVID-19 tests cannot be both self-administered and self-read by an employee. So if there's an at-home test taken by an employee, in order to be valid under Cal OSHA's revised ETS, that testing would either have to be observed by the company or observed by an authorized telehealth provider. Also, employees that are screened for COVID-19 symptoms at the workplace, both the screeners and the employees would need to wear face coverings even if they're fully vaccinated. Let's move forward one more slide. And lastly, there's some definition differences in the proposed ETS. COVID-19 is no longer defined as an infectious disease. The definition of face coverings has some additional requirements. Some of the new requirements are that the face coverings must be made of fabrics that do not let light pass through when held up to a light source. And it's really unclear how that will affect company practices in the workplace, or really what that means or how it will be measured. But that is something to note, that there is a slightly new definition of face covering, as well as the definition of being fully vaccinated. This will be expanded under Cal OSHA's ETS to include individuals who received a COVID-19 vaccine as part of a clinical trial, as long as that employee can document they received an active dose and not a placebo dose of the COVID-19 vaccine. And finally, the definition of worksite will be clarified so that to continue how it's currently operating, where employees who are working remotely or working in the workplace that have no contact with other people won't be required to abide by the requirements in Cal OSHA's ETS, which is really how companies are operating right now, but that's just clarified in the revised ETS. So like I said, this is going to be voted on today. So companies don't need to take action just yet, but this is definitely something to watch for and see as these standards in Cal OSHA, standards from Cal OSHA might change starting mid-January. So it's definitely something to keep on the radar and plan accordingly for next year. When it comes to COVID legislation, California is in the news a lot, but probably not quite as much as New York. So let's go ahead and move on to New York. It has been in the news a lot recently. There are 5 different pieces of COVID-19 legislation or guidance relating to New York City and New York state companies. So we've seen 5 different ones. 3 of those relate to New York City employers and 2 of which apply to the whole state. So in New York City, we've seen a vaccine mandate, expansion of New York City's passport program, expansion of earned sick and safe leave. And then in the statewide, we're seeing a mask mandate, as well as some revisitation of the vaccine mandate for healthcare workers. So I'll go through all of these, but wanted to give you a place to look at all of the momentum and movement going on in New York as it relates to COVID-19 right now. So we'll start with the COVID-19 New York City vaccine mandate. So this will go into effect on December 27th and requires all private employers, regardless of their size, to require every employee have at least 1 dose of a COVID-19 vaccine to go into a New York City workplace. Unlike the federal ETS, there is no testing out option. So employees can't be routinely tested for COVID-19 to go into the workplace. They must provide proof of vaccination, but there are medical and religious exemptions to that vaccine mandate. This mandate applies to employees who work in person with at least 1 other person. So those New York City employees that are fully remote, this would not apply to them. It's only employees who wish to enter a New York City workplace in person. Businesses have to verify and keep a record of each worker's proof of vaccination. And just yesterday, we saw guidance from New York City on 3 different ways that companies can satisfy this requirement. The first is that companies can retain a copy of an employee's proof of vaccination or that employee's record of an accommodation with their supporting documentation. So that's option 1, is to retain a copy. Option 2 is that companies can retain their own record. So create kind of a roster or a form that includes the employee's name, vaccination status, date of vaccination, or their exemption and similar supporting documentation. So option 2 is a company can create their own log. And then option 3 is that companies can check workers' proof of vaccination before they enter the workplace each day, and they have to maintain a record of that verification. So there's really several options. We don't have much more detail than that. That's what New York City told us yesterday on how companies can meet this requirement, but sort of the ins and outs of what that means and what that looks like, we don't have that information. So companies should start thinking about which method they might want to use to satisfy that requirement and how that might work in practice. And also, Businesses must post a certificate affirming that they comply with the vaccine requirements and post this in a public-facing location. This must be done by December 27th. So companies must have that sign up in their window on December 27th, and that's available on the New York City COVID-19 website, where it talks about some of the FAQs of the vaccine mandate. It's worth noting that employees that come into the workplace for a very quick or limited purpose wouldn't have to show proof of vaccination. So employees that enter the office for a delivery, to clock in, to use the restroom, wouldn't have to provide proof of vaccination, but all other employees would, and the company can be fined for $1,000 for violating this vaccine mandate. Okay, so that's the biggest one that we've seen right now, and it's causing a lot of flurry in the news and a lot of companies to scramble to comply with that because it is coming up very quickly. The second one that we've seen is expansion of the Key to NYC Pass, which is a vaccine passport program. So currently in New York City, people 12 and older are required to show proof that they've received at least one COVID-19 vaccine dose if they would like to participate in indoor dining, fitness, entertainment, or certain meeting spaces, such as museums, indoor stadiums, convention centers, or hotel meeting spaces. And people 18 and older must show proof of identification along with their proof of vaccination. So this is being expanded. So we have 2 dates, one of which has already passed and one of which is coming up. So starting December 14th, this Tuesday, children ages 5 to 11 are required to show proof of at least one dose of vaccine to participate in those covered activities. And then starting December 27th, the same day as the New York City vaccine mandate, people 12 and older must show proof of full vaccination to participate in those covered activities. And that proof of vaccination can come in several different ways. It can be a CDC vaccine card, it can be a New York City vaccine record or other immunization record from a healthcare provider, or it can be through digital methods or apps like the New York COVID Safe app, the Clear Health Pass, or the Excelsior Pass. And those are available to show proof of vaccination for individuals 18 and older. So what does this mean for businesses? If you are one of those covered businesses that providing those covered activities, you are required to check the vaccination status of all staff and customers who are ages 12 and older right now, but soon to be ages 5 and older. And you have to deny entry to those individuals who do not show proof of that they meet the requirement or they are not eligible for an exemption. However, businesses can allow people to come into their covered activities to use for a limited purpose, such as to use the restroom if it takes a short amount of time, such as 10 minutes or less. Okay, let's move forward. And then one more thing to note, under that Key to New York City Passport program, violations are $1,000 for the first violation, $2,000 for the second violation within a 12-month period, and $5,000 for any subsequent violation in a 12-month period. So the penalties can add up quickly, and those companies that are participating in those covered activities need to be ready to comply with all the way down for children ages 5 and up. The third thing that we're seeing is out of New York City is expansion of New York City's earned safe and sick time. So currently New York City requires companies provide certain sick and safe time for employees to become fully vaccinated. And that is in addition to the already accrued sick leave that employees might have. They have a separate bucket of time that they can use to become vaccinated. So in addition to that, that's being expanded and was expanded on November 23rd to expand to be eligible for employees to take their children to be fully vaccinated. So under this new amendment to the legislation, employees are eligible to receive 4 hours of paid leave to accompany their children to a COVID-19 vaccine exemption or injection, or to care for a child who's recovering from a temporary side effect from a COVID-19 vaccination. And it's important to note that this law doesn't distinguish between a primary dose of a vaccine or a booster shot. So all of those are eligible for employees to take leave under this act to take their children to become vaccinated. The child must be under the age of 18 or unable to care for themselves by reason of mental or physical disability. And this leave is in addition to the sick accrued leave that companies are already required to provide to employees and is in effect through all of December and through all of next year. So this act is set to expire on December 31, 2022. And employers can be subject to penalties if they don't comply with this. If companies don't compensate employees for the leave, then the penalty can be 3 times that employee's wage or $250, whichever is greater. Or if a company charges that paid time to an employee's accrued paid sick or safe time, that company can be assessed a penalty of $500. So all of these new laws and regulations have associated penalties that can add up quickly for companies. So it's important to kind of take note of all of these new laws, how they might apply to a company, and make sure that companies are doing their best to comply to avoid these potential penalties. So we're seeing 2 pieces of new COVID-19 legislation out of the state of New York. And this next one has been big in the news this week as well. New York announced a temporary indoor mask mandate in effect from December 13th until at least January 15th, 2022. So after Thanksgiving, New York State's statewide average COVID-19 case rate increased by 43%, and the hospitalizations increased by 29%. So New York saw a big increase in COVID-19 cases, and as a result has kind of implemented this new statewide mask mandate to try and crush that curve a little bit. So New Yorkers must wear a mask in all indoor public spaces unless they show proof of vaccination, because that business has a vaccine mandate in place. There could be fines of up to $1,000 for violation of this as well. And the counties are responsible, the county health departments are responsible for implementing this mask mandate. And if you see in the news, there are some counties that have already pushed back and indicated they will not be complying with this mask mandate, or as they say, they don't intend to become the mask police. So it puts customers and employees and companies in a tricky position, because there is a statewide mask mandate, but some counties have said, either due to limited county resources or they don't feel it's necessary in their county, have said they will encourage companies to require masks, but they won't enforce this statewide mask mandate. So that's something to watch for. It really is up in the air. Technically, the governor could send out resources to enforce this mandate statewide, but as it stands right now, some states might not really be enforcing it. And then lastly, earlier this year, we saw a vaccine mandate for healthcare workers in New York State. And that was implemented on October 26th and required employees to be vaccinated by September 27th, that deadline was delayed to November 22nd. And this regulation applied to healthcare providers such as hospitals, nursing homes, adult care facilities, hospices, birth centers, those types of healthcare facilities. And this regulation contained a medical exemption for employees who are not able to obtain the vaccine because of a disability, but did not have a similar religious exemption for individuals who will not be vaccinated due to a sincerely held religious belief. And this religious exemption was originally in the proposed emergency regulations, but it was later removed after feedback from the healthcare community that they were facing a really high number of requests for religious exemptions. And so New York State looked to other prior health crises, such as in 2019, the measles outbreak, where they implemented a type of vaccine mandate. It didn't have religious exemptions, and followed the approach that was taken then of having a disability exemption, but not a religious exemption. And also New York has indicated that individuals who have a religious exemption to the vaccine mandate, such as healthcare workers who have a religious exemption to the mandate, could still receive a religious accommodation, such as being reassigned to work in a different area or working remotely if that's possible, but there was no religious exemption as part of this mandate. So parties immediately sued, stating that this was a violation of their free exercise of religion. And the Second Circuit Court of Appeals upheld this law and distinguished it, saying that because there is a religious accommodation, that was sufficient, even though there was no religious exemption in the mandate, because it allows employees to allow them to continue working while avoiding the vaccine requirement because of the religious accommodation possibility. And so on December 13th, on Monday of this week, the US Supreme Court looked at this and denied an emergency request for an injunction to the mandate on the grounds that it prevented employees from the free exercise of their religion. So as of right now, this vaccine mandate for healthcare workers is still in effect in New York and will not be reviewed by the Supreme Court, at least right now. So there is a lot going on, especially in New York. I feel like I'm trying to keep track of all the different moving pieces and New York City as well as the state. So it's definitely something that we're seeing effective now, but also as companies look towards 2022, there's a lot for companies to keep their eyes on and watch for further guidance, as well as plan for compliance to what we already know will be in effect.
And Adrienne, we've had a lot of questions about California's mask mandate as well, because it's fairly recent. It just went into effect and will stay in effect till January 15th. One of the questions was whether it applies to offices. And I think that on its face, it does apply to all public indoor areas, including offices. But one area I think of confusion, at least that I see in the questions, is that the California Department of Health has exempted certain localities that had in place before December 13th, 2021, mask mandates that required people to wear masks regardless of their vaccination status. And so, for example, the 5 Bay Area counties had mask mandates in place that had limited exceptions, actually, I think, for offices that have a 100% vaccinated workforce. And so California companies should look at and see if their local county mandates are still in place. And I think that does add a little confusion, and that the state mandate may not apply on its face to some counties that had pre-existing mask mandates before December 13th. So we've got a lot of questions about that. And I think it shows a little bit of the nuance here, where you have federal, state, and local regulations that all have to interact in different ways.
That's right. Yeah, that's exactly right. It can get complicated really quickly.
Thanks, Adrienne. Now we'll turn the time over to Marie to talk about how we can take practical steps in the face of uncertainty and changing regulations.
And I might just lead off with, best practice number 1, stay updated on what is changing. This is a great example. The California situation is very confusing right now for the majority of companies that are trying to be compliant. And so, you can use a lot of different tools to stay updated and know what is required in the places where you have employees. And SixFifty does provide one of those. If you're a SixFifty customer using, our assessment, we look at that. And in California specifically, we have that county by county differentiation as part of our tool set. So, finding a way to make sure that you're staying up to date in the different jurisdictions that you're operating in is very important. If we could advance to the next slide, I'm going to be talking about best practices more generally. And so this is where we're trying to also kind of reset the lens. And in addition to everything going on with the federal ETS and companies sort of being in a holding pattern to know whether or not that's going to, the stay is going to remain in place, or is it going to be lifted, and companies will have to start complying with it very quickly after the new year. At the same time that California is like revisiting and potentially making some changes to its policy, there's a lot of movement. And that's because it's an ever-changing situation, right? We have the Omicron variant that's growing. We have, vaccination rates are continually changing. The vaccine availability has been expanded to younger children. There's just a lot of moving parts here that impact, what's the right thing to do for your workforce. And so we're going to talk a little bit about what that is in terms of the things you should be sort of checking and making sure that you're doing from a best practice perspective. So the first and most important thing is your organization should have a written COVID policy. In some jurisdictions, this is required. If the federal ETS is upheld, if the stay is removed, it will also be required for all large employers. So who have 100 or more employees, they'll have to have a written policy in place if they don't already have one. And just as a general rule, even if it's not required, it's still a best practice. And the reason it's a best practice is because things are changing so much that in order for you to really be able to have, safety measures in place that do protect your workforce and that also protect you against litigation potentially in the future, you need a written policy so that your employees know what's expected of them at any given time, because it is changing on a pretty regular basis. And so what should be in your policy? First, you need to have you need to address vaccination in that policy, whether you're requiring it, whether you're encouraging it. You need to address that there. You need to address whether there's exemptions that you're recognizing or accommodations that you're providing, and how someone would ask for those if they need to. You also need to address testing. So, there's a lot of legal situations in which testing will be required in different jurisdictions. For example, if you have an outbreak at your office, And then we also have, what I'm now going to start calling the traditional COVID protective measures: masking, screening for symptoms, social distancing, improved hygiene practices compared to what we all did before the pandemic, but which are now, I would say, the standard across the board. Also having a policy in place for quarantining, to determine when someone can come back to work after a close contact with a COVID case, or after they themselves have had COVID. Remote work options in both of those situations, whether they're available, and if so, how are they overseen? We've already heard a lot from Adrienne and Adam today about, payment. So, whether people are being paid when they're going to get vaccinated, whether, there's payment for testing, there's payment for time off related to COVID or to being vaccinated, and other benefits implications for your business. These are all things that are big issues, and addressing them so that your employees have an answer, so that you have a methodology to follow, makes a huge difference. And the follow-up to that is you have to make that accessible to your employees so that it actually is something that they can refer to, they can follow, and you can say, when the rubber hits the road, if a situation occurs, look, it's in the policy, you receive the policy, we have to stand by it in this situation. And that brings us to the second most important best practice. First, you have to write down what you're going to do and you have to follow it. Secondly, you have to communicate that to your employees. And so communication, really, I don't think we can overemphasize how important it is in this situation. So communicating your policy to your employees, which often is required by law, as we've just been discussing, depending on your local jurisdiction, it will be required by the ETS if it's upheld, if it gets out of court. So, specifically, your policy will have to say things, and you'll have to communicate additional things other than your policy under the ETS by law if it does get upheld. But these are things that, again, best practice, not just from a legal perspective, but from an operational perspective, from an employee trust perspective, you need to be telling them. And so you also need to let them know what process is going to be used to determine if they're in compliance, so that you don't have some sort of process where you're always checking on some employees and never checking on others. That can lead to some disparate impact situations at companies. So you need to make clear what process is being used, make clear to them what time and pay or leave they're entitled to for both their vaccinations and if they're experiencing vaccination side effects, procedures that they have to follow. So I'm an employee, I get tested for COVID and I get a positive test. Do I have to tell you as my employer? If I have to tell you, who do I have to tell? I need to know those things so that I can do what's expected of me to help protect all of my coworkers. And I'm not left in limbo trying to be like, oh, well, I told Joe, who I share an office with, but I didn't tell Jill because I only saw her in the break room that one time. So I didn't tell her about it. You can't leave it to them to notify all the right people and potential close contacts. You have to take responsibility for that as an employer, because you have a responsibility to provide a safe workplace. So all of these things need to be communicated really clearly. You also need to clearly communicate, any face covering rules, any differences in rules that you have for vaccinated versus unvaccinated employees if you are collecting vaccination information. And also the fact that the policies can be updated at essentially any time, because things are changing so often. So they need to know, look, this is what we're doing now. But that doesn't mean that in 2 weeks, in a month, this is still going to be the way we're doing it. We may change it. And that's hard for employees. They like to have expectations that they can, stick with and follow, that they can plan around. This is a hard situation. People have childcare situations they have to account for. School closures are happening. There's a lot going on for employers and for their employees. And so the more we communicate, the more we'll be able to move forward in a compliant way that also helps your workforce stay engaged and get the work done. So those are, I would say, the first most important two things. And there's a lot to unpack inside of those. Let me just talk for a minute about, as a follow-up to that, what records you should be keeping right now during the pandemic. So you need records of the policies that you're putting in place. so that you can show like, this is our policy at this time. We shared it with employees at this time. So you need to be able to show that in case there ever is a situation where you're audited, or where there might be, we hope not, but if you ever have any litigation come up. You also have to keep records if you're tracking vaccination status, if you're doing daily screeners or healthcare screeners, if you're doing contact tracing and investigations. Those are all things around which you will create a record. And then you have to know what to do with that record. So most first item of business, just know medical records have to be kept separate from the regular personnel file and confidential. There's records retention rules. The longest record retention rule that you'll probably have to comply with is OSHA, which has a 30-year medical record storage requirement. That is difficult. What you want to make sure that you're doing is that you're storing information in a place and in a way that you'll be able to comply with that. There's the chance that will be shortened for some things. I have a little asterisk on the chart there. A vaccine card is a medical record under federal OSHA. Cal OSHA currently exempts that card from the 30-year record requirement. And in the future ETS, if it does get upheld, it may also be exempted in that situation. But under like the regular rules of OSHA, a card like that would be a medical record. And under the Americans with Disabilities Act, you have to keep these records for at least 1 year. And again, like if it's a medical record, a minimum of a year from the time that the record was created or from the end of the person's employment, whichever is longer. So that's the situation on that one. So just be aware, keep your records confidential, keep them separate. Don't give access to all of your employees to their coworkers' test results. That's problematic. You don't want to do it. And then we have some additional best practices that I went into more depth on. A big one is masking. And this is where we talk a little bit about the difference between a legal requirement and a best practice. A lot of people on the call today are operations and HR individuals, and you're aware of this big space between absolutely required and best practice. There's a lot of room there for movement. And I would just say, as we've already examined with all the different jurisdictional rules right now, be aware of what the CDC is advising on an ongoing basis. We have, despite like feeling like, oh, we have to do what we're told to do and nothing else, that's not really true. Like we have these regulations from federal OSHA, from your state OSHAs, from your like local health departments and all of these different places that are telling us the minimum. The minimum is not always going to be your best practice, and it's changing pretty regularly. It can be hard to track, but the CDC does give us some general guidance, and one of those things is that if you're in an area of substantial or high transmission, everybody, regardless of vaccination status, is currently being told like you should mask. If somebody is immunocompromised or at higher risk for complications, they're encouraged to mask, and the people around them are encouraged to mask. So think about all of those situations when you decide what your rule is going to be. And if you're in a situation where you're not legally required right now to collect vaccination information about your employees, you might want to consider treating everyone as unvaccinated if you do not know the vaccination status of your workforce, just so that you can implement as many protective measures as possible, short of collecting that information if you're not collecting it. I was working with somebody yesterday who we were talking about this issue, and they have a work site. It's a big construction company, and they're dealing with subcontractors. They're dealing with multiple people on sites coming from different employers, and trying to figure out that person is part of a big company, and so they have to wear masks because they're governed by this rule, and this subcontractor is not. It's just a really big mess, and they don't have a way to track everybody on their sites. They said, look, we're just going to make everybody mask all the time. We're going to have physical distancing rules in place. We're going to do all the things we know can help stop the spread, short of having some sort of rule that requires everybody to record the vaccination requirement, because they're not in a state where that's currently an option. So that's a good best practice workaround that you could implement across different suggestions like masking. screening, social distancing practices, all of those. And with that, I just wanted to let you know, we have additional in-depth slides on other best practices that we'll send to you as a follow-up. But right now, we wanted to do some wrap-up questions. I wanted to see if Ryan wanted to join us. And while he's doing that, I will answer. I saw a question come into the chat about HIPAA. So HIPAA is interesting. A lot of people will tell you, like, you can't ask me that, it's HIPAA protected. And it's usually not true. HIPAA usually doesn't apply, is typically the answer. HIPAA is about the release of medical information, not about the collection of it. So you asking an employee or a person coming into your work site to see their vaccine card doesn't implicate HIPAA. However, the release of that information would potentially implicate HIPAA if you are covered by it. And so that's the thing where, just keep in mind, the majority of organizations are not covered by HIPAA. If you're a medical care provider or one of the covered providers, then it would apply to you. But the majority of businesses are not in that space. So if people say, you can't ask me for that, it's my HIPAA right not to give it to you, they're probably wrong.
Thanks, Marie. We've had a ton of questions. I think we've answered nearly 20 questions, and just we'll be sending out both this webinar and the questions and answers following the webinar. One question that we had was interesting is, and this is something we've covered in past webinars, the interplay between federal and state OSHA. And that's an issue that can be a little confusing. Marie or Adrienne or Adam, would one of you like to just address that? We only have a short amount of time, but give us an overview of the relationship between federal and state OSHA and what that means for the various ETSs that have been put out.
I might start that one because I think I had talked with someone about that in the chat. So there are 21 states and Puerto Rico that all have their own OSHA plans. Those plans are approved by federal OSHA. So they're required to be at least as protective as federal OSHA is. And so if they are not as protective, they are at risk of losing their federal approval. 3 states recently have been issued letters being told that they're at risk of losing their approval. Those states are South Carolina, Utah, and Arizona. Not a lot has happened after the letter was issued, though, and I think that's because of what's going on with the litigation surrounding the federal ETS. But at the end of the day, your state OSHA plan, if you're in one of those 21 states or Puerto Rico, will be required to issue its own rule, its own ETS. If the federal ETS gets upheld, that would be at least as protective as that federal rule. So if you're in a state and you're sitting there thinking, like, I'm in Utah and I'm thinking, oh, like, we might not have to do that even though we have 100 employees because Utah might not pass a similar rule. That's not correct. It has to pass a rule that's at least as protective if the rule does get upheld.
Thanks, Marie. And I think that covers a question we had maybe about Montana and other locations where they're thinking about the ETS and whether they should begin to prepare, whether your state implements federal OSHA standards or state-specific standards. If the federal ETS are upheld, it will have to implement something that is at least as restrictive as the federal standards. And so I think it is a good idea to be looking at those standards and preparing to implement them. We're up against time. I want to thank Marie, Adam, and Adrienne for all the time and effort they put into preparing the presentation, and thank all of you for joining us for this webinar. We had a lot of great questions and participation, and we hope that we'll see you at future 650 webinars. Again, if you're interested in learning more about 650 products, including our return to work site tool set that includes weekly updates about the changes in the law, also our Cal OSHA tool set and our New York HERO Act generation engine, feel free to visit us at www.650.com/return. And with that, we'll close the webinar. We wish you all a great day and hope to see you in the future.